Good morning. Yesterday I have circulated a copy of petition filed by husband who is earning more than 80,000 rupees salary, holding a highest executive post. Initially, he has tortured his wife like anything by hiding the two children for weeks together, and only on intervention of police the children were rescued, and that made him to desert his wife. Thereafter, he seems to have inducted a tenant who seems to be city civil court staff. With his influence, he engaged in an advocate and filed OP for dissolution of marriage on the ground of fraud, misrepresentation, cruelty. He did not file because two children are there. One children is 7 years, other children is 3 years. Then there were counseling. He intelligently influenced the police when inquiry was there, sending her Nirbhaya, and Nirbhaya people who was influenced sent this girl to psychological doctor, and on their advice she was directed to take some medicines, and accusing that they filed a petition that she is taking whether that ground is tenable or not, that is different. Then what had happened before the counseling family court appearance, second counseling the husband was willing to take her back, but subsequently third counseling he refused to take her. Then because this clerk was influencing, the tenant clerk was influencing the court, then what had happened? Initially, on seeing the child, the judge directed him to pay maintenance, and that had happened very earlier. But till date, neither he paid any maintenance from 24 to 2023. But he did not pay any amount. And now what had happened? 24 application has been filed. That was not properly attended to. The husband did not file counter nor assets and liability or statement of bank. Then he files 3 petitions. That 3 petitions filed by him. It was passed over in the morning, and unnecessarily for check and call on, the judge had to instructed the wife to come or follow the date. But that was not no problem because of business is in charge of two. But that the clerk, passing clerk, mechanically passes the order. He says, he called advocate and says this petition is not maintainable because you want permanent custody. Petition filed under section 26, which is meant forward. Then he immediately strike and says temporary custody. There ends the matter. She numbers it. And thereafter, he directed the advocate to say represented by. The petition was, a respondent was, he simply write represented by father. Whose father? The clerk's father or his father or whose father? Name, nothing. Same with the 45 application. Bare 45 application read with section 12 of the Family Court Act when filed. There also they simply say wife represented by father. Whose father? What particulars? This is where they are numbering for consideration. The shame of it. Those who pays money are attended very casually, lethargically, anyhow earning like Burma Bazaar vendors. This is a state of affairs. And see, my client is very poor, innocent. Otherwise, I can file writ 227 to teach them all lessons. And the counsel appearing for the respondent seems to be physically handicapped. The clerk who is passing he is also seems to be handicapped. What can I do? I do not want to punish them. They let them repent themselves. That this sort of causing that how can I charge a poor lady who is not having money to maintain two children for filing writ petitions, dragging to the other courts. Let me see and face the very same court, because you see I am collecting huge fees in criminal side practices and writ matters, and I am being engaged by the other young advocates, and they pay meager fees I collected. Therefore, for my satisfaction at this age, I used to help these poor ladies. But this is what happening. What to do, what not to do. Uh, the thing is very worst. Somebody should interfere with this family court. Another thing was, yet another grievance was, in one particular court, I am informed that in several courts, particularly 15th Metropolitan Magistrate Court, there were 7 matters for which orders were reserved, and orders yet to be passed for 1 year, 7 months, 1.5 years. Very sad state of affairs. In family court matters also, simply adjourning orders reserved, clarification orders reserved, clarification. What is actually happening? And too sad. This should be interfered with, otherwise we cannot claim that our judiciary is. I have sent a complaint to Registrar General and Register of Vigilance also. Let me see how they react or work on these issues. Whether whether they have got patience to read the paper sent by me, or they want me to produce the copies, or they want to trouble me. In early one occasion, I lodged a complaint against one session judge who has passed an improper and irrelevant order mentioning different crime number. That vigilance officer calls me and you give statement. I said, what statement do you want me to? I brought to you the affairs, state of affairs of the particular judge who passes these sort of orders. I want that this should be brought to your notice. It is your duty. I have no grievance against the judge. It is not my matter. But on going through these orders, I am astonished. See, a fantastic thing in that order was bail granted on 13/11/2022. Thereafter, within 7 days, relaxation filed. Relaxation was granted, stating that he is complying the condition for the past 1.5 months. Therefore, I said bail was granted only just now, 7 days before, and the learned judge, PP also says that he is complying. Probably PP would have, by referring other matters, would have represented it. But it is the duty of the judge to verify the date of order and what is the. And the order was dictated, it was typed and signed. This is the way judges are working. Huh? Okay, what else I can do? Sarvojana Sughi Bhavantu. Best wishes.